Tilburg University and MindLabs present TAISIG Talks, the podcast that keeps you updated on the latest developments in the field of artificial intelligence in just 1 hour.
Welcome to this edition of the TAISIG Talk. My name is Pieter Spronck. I'm a professor of computer science at Tilburg University. I'm also the head of TAISIG, which is the Tilburg Artificial Intelligence Special Interest Group. I am here today with a co-host, Aimen Taimur. Aimen, can you quickly say something about yourself?
Yes, thank you, Peter. I'm a PhD researcher at the Tilburg Institute for Law, Technology and Society. My PhD is focused on manipulative technologies, and I have a human rights background, so that impacts a lot of my research in terms of how emerging tech is now interacting with our established fundamental rights.
Yes, thank you. Yeah, so it would be very interesting to have a podcast about that particular topic, but we have a guest today, and that is actually the topic that we are going to discuss today. And the guest is Taner Kuru, and the topic is the legality of data trolling. Now, this is not a term that is very common, so Taner, perhaps you can introduce yourself and say a bit about what data trolling actually is.
Yep. Hi, everyone, and thanks for having me here today. And I'm also a PhD researcher at TILT, like Aimen. And interestingly, my PhD is not actually on data trolling. It's actually on the ethical and legal implications of a novel use of forensic DNA, which is called investigative genetic genealogy. But this was kind of like a funny side project for me. A bit maybe productive procrastination, maybe, if you ask to my supervisors. So the data trolling term that I used in this paper, it's to actually identify a concept, and that is, broadly speaking, the mass processing of personal data out there that is accessible on the internet, on the web, to train AI models, and in this context, large language models or Gen AI models. And I used it because, to me, it resembles a technique used in fisheries called bottom trawling. And in this technique, that's they use big, heavy nets to drag seabed to catch large amounts of fish or marine creatures at once. And then, if they could, they filter those who were actually hunting, and it may contain some species that are even protected, or they should not be hunted, or fish. I don't know the exact word for that. And because of that, it damages the ecosystem, and therefore they also are prohibited or banned or restricted in certain marine areas in the world. So it resembled a bit, when I was writing this paper, that technique with its procedures and also its implications. So that's why I make this draw the similarities between these two concepts and call this processing activity data trolling.
That's very interesting. Now that I think about it, when data is scraped from the internet, there is this underlying assumption, maybe on part of the people training these AI models, that the information on the internet is free to use, regardless of where it's coming from. Why do you think that this assumption is so widespread?
I think it may be a bit of an American understanding of what privacy is. But we have the GDPR, and I'm a data protection scholar, so to me it is obviously not the case that just because something is out there on the internet that is freely accessible, that you can use it for any purpose by any processing method as such that you would like. So I think it also comes from a bit that mismatch between the ideologies regarding how privacy is understood. But obviously, it doesn't necessarily mean, as far as I know, also in the American context, American privacy discourse, that just because something is out there, you can use it also. But it's the main argument I think it derives from.
From a more data protection perspective, large language models, they process both ordinary and personal and sensitive data. What kinds of risks does this pose that most people might not see?
We have, in the context of large language models, for instance, the hallucinations issue. So it may produce misinformation, sometimes even defamatory statements. I see recently, for instance, Noib again filed a complaint. I am having a bit of hard time to remembering the facts of the case, but I think ChatGPT outputs falsely accused someone murdering the kids, but something like this. I really need to check that again. But
well, there are actually a couple of these cases where ChatGPT is asked for information on people and they give information which is simply incorrect. You see that actually quite a lot of these cases going. And murdering, of course, would be really bad, but it's also in smaller cases where people, for instance, I've seen this actually, that there are HR managers use ChatGPT to get information on people who apply for a position, and then it begins to lie about it. So they say, tell me what the bad things are that this person did, and you get a bunch of bad things that they never did. But yeah, ChatGPT cuffs them up.
Yeah, and it's one part of the issue that we're addressing here, I guess, because it's also like not just the output, but it's also a bit the input. So that's also one side of the problem. But yeah, I think one of the biggest issues regarding what you ask is relating to the hallucination issue, that it may create false information about individuals who may think that is harmful for them, for the reputation, etc.
I agree. Now that leads me to a question that may be very basic, but I think it's an important one to ask. That do you think that massive data sets are essential for training powerful AI, or is this a genuine technical need, or is it more of a convenient narrative?
I can maybe give it a bit of a legal answer. So in the EU data protection framework, you need to have a legal basis for your processing activity in principle. So in this context, we mostly focus on one specific legal basis, and that is enshrined in Article 6.1f of the GDPR, which is called legitimate interest legal basis.
Can you, before you continue the answer, I think you're already delving in rather technological terms. And of course, when you look at the university, many people have to work with the GDPR, but this podcast spreads a bit wider than that. So maybe you can sketch this environment out a bit more so that people understand what we're talking about.
Yeah, sure. So we have the GDPR, as you may have heard already, and that is basically the cornerstone of the EU data protection framework. And it has certain obligations towards people who process personal data for various purposes. And one of those obligations derive from the principles that applies, again, in principle to all data processing activities out there, and that is called the lawfulness principle. And based on this lawfulness principle, you need to have a valid legal basis to process the personal data. And those are enshrined in Article 6 of the GDPR. One of them you may have already heard, consent, which is quite notorious. But we have, and the other one is, for instance, contractual necessity. So for instance, when you make an online purchase, let's say Amazon, they need to have your, let's say, delivery home address for the delivery. So when they process that data, in principle, they rely on this contractual necessity legal basis. So we have one other legal basis, that is Article 6.1f, which we call the legitimate interest. It allows personal data processing activities as long as you pursue a legitimate interest, with some technical details that I will go further in a bit. But first, we have, regarding this legal basis, what we call the three-step test. And the first one is that you need to have a legitimate interest that you're pursuing. And in this case, it could be, for instance, the product development or training your model, etc. It also has its own match list, but in this case, we can say, yeah, you can pass this quite easily as long as your interest is lawful. And the second step relates to what Aimen just asked, and in this second step test, we check whether the data that you process is limited to what is necessary to achieve your purposes, or whether there are any other less intrusive alternatives that you could have gone for. And in this specific instance, one of the debates actually even before this whole discussion, whether AI processing in general could even comply with this principle or requirement, because AI needs data to be more effective, to be more powerful, etc. But we have data minimization principle, and in this specific legal basis, this necessity requirement. So how can we make sure that we can actually comply with this, while also making sure that AI systems are trained with the data that is needed? So when this news started making their way to the headlines, so to say, like large language models and Gen AI, like web scraping, data scraping, like mass processing of personal data to train them. We started seeing a bit of how can I say, fragmentation in the answers to these processing activities. Like one, I can give the example from the ICO, the Information Commissioner's Office of the UK's Data Protection Authority. And they went for a call for evidence for many purposes, but in one of them, they also said that, well, as we understand, they really need to scrape or use mass amounts of data to train these models effectively. So we're looking for your response, input, answers, whether this assumption is correct and how we can move forward further with this. But on the other hand, the opinions from the EDPB, European Data Protection Board, and also the European Data Protection Supervisor, EDPS. Sorry, I always use the abbreviation sometimes, you forget what they stand for. So they said, and I can describe these institutions to non-data protection people, those who have a saying in EU data protection framework. I'm not belittling obviously data protection authorities, don't get me wrong, but they are the ones we mostly look up to, what are they gonna say? Unless there's a CJU case or something. But anyway, so they said, for instance, explicitly, technical impossibility to comply or these kind of technical rhetorics cannot be used to justify not complying with one of the fundamental principles of data protection law in EU. So they were actually going forward no, we need to find solutions even if this is really the case. We need to somehow make it more compliant. And if I'm not mistaken, I also remember that ICO also came towards this point in their second call for evidence or kind of update on that, but I need to check it further because it's just a memory on my mind right now. But yeah, so coming back to your question after this long introduction, I'm not the one to say anything on this, obviously, because I'm not a computer scientist or I cannot make a really informed comment about whether do they really need these data sets or not. But coming from the data protection background, I can say that yes, I think we need to somehow find a way to limit it to what it is necessary.
Yeah, I understand that completely. It is a bit of a difficult balance to strike, especially with so much competitiveness, even when it comes to AI development. I think now I would like to shift the focus a bit on the data subjects, because that's indeed, I think, the most crucial part of this conversation, that people don't know that their data is being scraped. So how do you see this in terms of the invisibility of this, such an important and also such a dangerous practice that people don't know what kind of data of theirs is being used to train whatever kind of large language models? How do you see this, and how would you recommend that this be dealt with from more of a legal rights-based perspective?
Yeah, I'm thinking where to start, because I think we need to take a step back to actually, before discussing large language models or Gen AI models, I think the first big example that we saw this mass processing activity to train AI models was actually Clearview AI. And
Sorry,
that was
what kind of AI?
the Clearview AI case.
Oh, Clearview, yeah.
Yes.
Yeah.
And for those who may not be familiar with it, this was a facial recognition app produced or developed in United States. And if I recall correctly, it was firstly, it had around 3 billion images in the data set or something like that, or mostly, or maybe entirely consisting of facial images of people accessible online that's just being scraped. Such as for instance, maybe LinkedIn profile pictures or something like this. So then it was being secretly sold to law enforcement authorities around the world, and also to some surprise wealthy individuals, etc. So when it was exposed, I think it was early 2020 or 21 by a New York Times reporter, Kashmir Hill, it attracted a lot of attention, and obviously from the European data protection community, especially data protection authorities, and we started seeing fine after fine being imposed on this processing activity, on Clearview AI specifically. And if I remember correctly, some of the data protection authorities also went after the law enforcement authorities actually used this facial recognition tool. So what was the problem here was actually what you touched upon, that we were not aware, but most importantly, that we also see it in some of the legal basis discussions as well, that we as data subjects or individuals, that people who put our facial images out there for different purposes, we could not reasonably expect that these images then later be used to develop a facial recognition tool that would be used for law enforcement purposes. So that's one of the issues that's I think we need to consider. Yes, we are not aware, and there may be different purposes. Maybe not for it is not as controversial as a facial recognition tool used by law enforcement authorities than developing a large language model, but it may be context specific, domain specific. I can give our example from academia, that we are funded by taxpayers' monies, and we promote open science, etc. And mostly we try to put our papers out there open access, but the whole purpose for it is actually to promote scientific knowledge, because we have that duty. But then enter large language models, then or Gen AI models, then our work is also being used to develop these models. I'm not making any normative statement whether it should be allowed or not, but it wasn't our expectation to when putting these papers out open access, that we could also feed into these algorithms that could build on these models. So here, coming back to your question about whether we know or not, I think it went a bit beyond that. Now that we somehow accept the fact that yes, once we put things out, it may be used for various purposes. Now also what we see from the responses to these practices from different data protection authorities, and also EDPB, EDPS, that the purposes they're actually used for make the difference. Because what we see, what at least I see, the difference is in the responses given to Clearview AI and these large language models. For the Clearview AI, for instance, it was quite straightforward and strict, no, we don't want this. This is quite controversial, fines. And for the large language models, we first had the discussion. Yes, for instance, the Garante fine and stuff, but we first had a very broad discussion about what is this? It looks it is being embraced by consumers, and how are we going to respond to it?
Can I ask a little bit about this? Because you said we accept that this data is used. So who is the we here?
All of us.
Well, I don't accept that.
Yeah.
I mean, so what I'm thinking is, so I publish papers and they are open access. I write a blog that is also, it's all online. I've written lots of stuff that's online. And as far as I know, maybe something has changed here, is when you write something or draw something, you have copyrights. You don't need to apply for copyrights. You have the copyrights. That means that I can decide what happens with this. So if I put something on the internet, then, well, my intention is that people get to read it. Now, if someone says, I steal your stuff and I'm going to use it for something else, I don't agree to that. I think most people wouldn't agree to that. They would say, look, if you really want my stuff, sure, you can get it. Maybe we can talk about it. Maybe you have to pay me something, or maybe, no, I don't want that. So what is the argument here that we accept that?
Yeah, so you actually open a very valid discussion. It's the interaction or disconnection between intellectual property law and data protection law. And we actually organized a workshop on this very specific topic in last September, where we brought together IP experts and the data protection experts. And afterwards, I could also see from the other discussions too, also from the EDPB's famous opinion, it was also being praised and also criticized in both senses, that it didn't touch upon the IP related issues, because I am not the expert in IP for sure, it's definitely. But when I hear what they say, or when I talk to them, when we come together, you can see definitely the two different worlds in that regard. And all the remarks that I'm making here is totally related to data protection framework, because one of the discussions is that whether and to what extent licensing agreements that these developers might come up with, or they already concluded, could justify their processing activities. But that's one of the topics that I see it's not really being touched upon from the data protection scholars, because it really is a bit of a tricky field. But that's definitely one of the valid arguments that you also just mentioned, the clash or interconnectedness. I don't know how to define it, between IP related issues, IP law related issues, and data protection related issues. But that's definitely, yes, indeed a valid stance. And we already started seeing that, I think it was Taylor and Francis that made an agreement with one of these developers, and it attracted serious attention from academic community. But I hope I didn't give the wrong name, but I think it was that. So yeah, we also started seeing in real life such consequences.
I think my next question is going to be about the chilling effect of mass data collection. How do you see the future of freedom of expression and free speech looking, considering the fact that data is being scraped on such a mass level? I mean, data trawling is only going to get more and more common as AI models are introduced, new ones are developed. So how do you see that? How is it going to impact people on a more societal level, where they would no longer be sure that whatever they're saying is not going to be just shared on their accounts, but as long as it's public enough, it could be used for training a large language model, and that could possibly have bad consequences for them. So how do you see the future of free speech and freedom of expression?
I'm not sure if I'm the competent person to answer this, because whatever I will reply to this question with, it would come from data protection, bubble that I'm living in. So that's why I would definitely like to say yeah, people are concerned. They would like to see more appropriate safeguards and mitigation measures to be implemented and stuff. But I would happy to see and love to see actually some empirical research on this, or the wide scale, I don't know, maybe surveys or something, to understand whether and to what extent this is actually a concern, to individuals out there beyond data protection, sphere.
So following up on that, I think maybe I can give you a bit of an example about what I mean. So for example, OpenAI is very vague about how they use the different sources that they use, and we're also not very sure about the exact sources that they use in their data sets. Do you think that there should be at some point a public mandatory disclosure of what they're using and what for? Could that potentially solve some of these problems?
So transparency is one of the other principles that I started mentioning at the very beginning of the talk. So based on that, they indeed not only OpenAI but all the other developers out there, or data controllers, in principle they need to comply with this transparency principle, meaning that they need to tell us about what they do with the data, how they collect the data, what are the purposes of this data, etc., etc. And obviously there are also certain procedural requirements to do so. And I can give you one specific example on this, specifically OpenAI and ChatGPT example, that the Italian Data Protection Authority, the Garante, obliged them to actually run a public campaign. And you can find the details in around 45 pages long of an Italian document that you need to definitely use an AI tool to translate and read. And there that they also make some specific statements on how these public campaigns should be held, and some other details. But I'm not sure to what extent just the transparency compliance would solve the issues relating to data protection framework, but definitely that's a starter. And yeah, for those at least interested in these discussions out there in the public, it would maybe make them more informed about their decisions and acts online. But yeah, I would definitely like to see a bit more broader discussion and surveys or empirical research, and to what extent this is actually a real concern.
But I actually don't think that transparency would solve anything, at least not immediately, because what these companies claim is, first of all, once I've trained the model, I don't need the data anymore. So, and I cannot get the data out of the model. So it's gone in there, used to train, data is no longer needed. It's just a bunch of numbers. So you cannot claim that your text is in there. So that's one thing that they say, and especially because they cannot retrain it anymore. It's already there, it's done. And I can also say that I don't need transparency of OpenAI because I know what they use. everything that they can lay their hands on. So basically they've used all the data that is there. They just pulled everything out of the internet and trained on that. They want as much as possible, and that's actually one of their big problems. They cannot find anything more. They're done, basically.
Yeah. Again, I'll refer to this Garantes decision, and there, they also explicitly mentioned some of the details from the hearing that they had. I don't remember obviously the date of the hearing, but I think it was a year and a half ago or something like that, where OpenAI presented some of their training processes, and what kind of mitigation measures or opt-out measures that they implemented with some screenshots and stuff. And there you see what kind of technical tools that they have to actually address these kind of issues. But one of the questions that I was asked recently was that actually a very valid question, that even if these developers say these kind of tools that we have and all those kind of statements that they do, whether data protection authorities in Europe are equipped regarding staff or expertise to investigate whether it is really true or not. And I think it was a valid question, because I remember so many studies, and I think it was one of the most striking ones was conducted by Brave, I guess. I can't remember the year, but it was kind of a survey checking the staff and the resources of European data protection authorities, and it was quite heartbreaking to see the numbers. People, for instance, how many European data protection authorities actually have technical expertise, the staff numbers to run the business, so to say. So I'm not really sure, even if they do, or maybe they don't, these developers that comply with the requirements, whether the people, the institutions who will go and investigate whether this is really the case or not, would have the capacity to do so. So that would be also one point to consider.
Well, I don't know exactly what you want them to test, but it's fairly easy to see that certain data has gone into something like ChatGPT. Because if you say to ChatGPT, can you write for me a story about a young boy who has become a wizard and lives in a closet underneath the staircase, you get the first paragraphs of Harry Potter. And a few words are changed because it can insert different words in different places. But it's clear that this text is stolen. It's just what you put in there, you can get out again if you ask the right questions. So how much technical knowledge do you need to have to show that?
Yeah, indeed. You can tell that or prove that, what kind of data is included in the data set or not. I guess you can do that technically. But from the data protection perspective, then we need to check whether that data is legally implemented in the training data set, and also maybe to a certain extent the output that's it affects. So yeah. The weird thing is that you talk about legality, but it seems that, and I'm not a lawyer, so I'm talking here from pure perspective of a computer scientist. I would say that it is by definition illegal, as far as I understand it. If I write something and you take it and do something with it without my knowledge, you have stealing from me. So, and stealing is illegal. That is what I would say as a naive person who interprets this stuff. And so I think, is the talk then about changing the legal rules or interpreting them in such a way that you are allowed to steal? Because I know that's what they try to do in the United States now, that they want to give the big tech companies actually, they are now allowed to steal. That is the idea. So if it's on the internet, you can steal it. That's what they can do. So they just take away your rights and give them to people who are very rich, basically. Okay, I think I now understand your question. Okay. Sorry for the miserable answers that I gave previously. So in the EU data protection framework, it doesn't work as such. I can tell you that. Because of the principles that I mentioned, for instance, like the lawfulness, and specifically I will answer through that perspective. So just because, coming back to the very first point that Aimen also raised, that just because something is out there on the internet that is publicly accessible, you cannot process it lawfully in the EU data protection framework. And here I would like to also make like one statement that normally when you do your research on these topics, you would see publicly available as the term. I use publicly accessible purposefully because I think availability gives a bit of a justification, but
Yes.
just because something is accessible, it doesn't make it available for further purposes. Just to make that clear. So coming back to the legal discussion, so to say, as I mentioned, you need to have a legal basis for your processing activity. So I will briefly explain this whole discussion regarding mass processing of publicly accessible data to train Gen AI models or AI models, large language models. So the discussion that we have now is whether and to what extent these developers have a legitimate interest in this processing activity. So the first step is we check whether they have a legitimate purpose or interest or not. And as long as this purpose is lawful, then we say, okay, green lighted. And in this case, it can be product development, training AI model, etc. It's fine. The second one is the necessity test. As I explained, we check whether the personal data that you use is limited to what is necessary to achieve your goal. And here we have a bit of a discussion whether this whole scraping or the mass processing activity is limited to what is necessary, or whether you really need it to actually make these models perform or come alive even. But the most interesting discussion for me is actually on the third step test, which checks whether there is any overriding rights or interests of data subjects, meaning us, like individuals, that could actually sideline this legitimate interest. And there we have certain consideration points that we always address. And one of them is, for instance, our reasonable expectations. And coming back to the same example of academic papers, like this article, for instance, is my personal data, right? And as I explained, my reasonable expectation, while as someone who's funded by university, but taxpayers' money to put it open access, is to disseminate the scientific knowledge. So my reasonable expectation when putting it out there as open access is not really to feed an AI algorithm, may it be a large language model or whatever, to learn from it. And again, I'm not making a normative statement. I'm just saying what is the reasonable expectation here or not. But just because I have this reasonable expectation, it doesn't mean OpenAI or any other kind of developer out there cannot use these data. Or for instance, Clearview AI cannot process my facial images out there just because I was not expecting that. Because they can actually use certain measures to bring the balance in their favor back again. And what we call several types of measures. That could be, for instance, technical measures that they can apply anonymization or pseudonymization techniques, or most importantly, what we see from the European Data Protection Board and some other relevant opinions as well, we nowadays focus on excluding certain data sources. It is always advised, now that we don't have a lot of decisions out there, but it is always advised for these developers to exclude certain sources or websites, etc., from their data set, or provide tools for individuals to blur, exclude certain personal data if they see any issues, etc. So this is the whole discussion regarding the lawfulness of it. So what I want to bring to this discussion is actually we are keeping the Pandora's box closed. And again, this is not a normative statement that I'm not sure if we should open it or not, but we have yet another so to say, requirements in the GDPR, in the EU data protection framework, and that relates to the sensitive data processing, what we call. Because in Article 9 of the GDPR, certain types of personal data categories, for instance, political opinions or like health status or genetic data, sexual orientation, etc., are considered sensitive and categorized as special category of personal data, and processing them is prohibited unless you rely on one of the exceptions listed in the following provision, which is Article 9.2. And we had recently quite interesting developments in that regard, coming from the Luxembourg Court, the Court of Justice of the European Union. And I'll focus on two of them. The first one, the court, how can I put it, not being very legal, so basically said that not only, for instance, the personal data that is by nature sensitive would fall under this definition, but personal data that is not by its nature sensitive, but indirectly could reveal sensitive data about somebody, can also fall under this definition. So in that case, it was, for instance, the partner's name of someone, and then you could tell the sexual orientation, etc. So then the court said, okay, by nature it is not sensitive, but indirectly it is. I hope it is clear to everyone is listening is also not a lawyer. So
Maybe another example is that you have these things that you can ask during when you apply for a job, and they are allowed to ask you certain things, and certain things you are not allowed to ask. But you have data that you can. So if you ask for someone's postal, someone's zip code, then you can derive where they live, and that gives already an idea about their, let's say, their class in society, etc. So, but you still ask that, of course, but the data is still sensitive in a sense because you can derive more just from knowing in which house someone lives. For instance.
Yeah, that's the main idea behind this decision as well.
But that also means that. And you had another example, so maybe you should go to that. But one thing that I've learned from working with lots of data, and as a computer scientist, I work with lots of data, is that it's very hard to hide certain things. So you can say, oh, I'll take someone's name out of this. But then you see, yeah, but I know his blood type, and I know this, and immediately it starts zooming to a very small number of people. So you can pick out which student it was that was giving certain answers. So but if you want to completely blur that, it's almost impossible.
Yeah. So that's also one of the underlying,
especially with AI. That's
yeah. So we have this decision, and the second one is coming from the Meta versus Bundeskartellamt case, which is a landmark judgment we consider in the data protection bubble, so to say. And there, the court specifically said, and interestingly said, if you process personal data on, for instance, large scale, and both sensitive and non-sensitive data, and block without being able to separate them at the time of the processing, like what is sensitive and non-sensitive, then you need to apply Article 9 framework, like a sensitive data processing framework, to the entire processing. So bringing these cases together in this context, like mass processing of personal data out there on the web, publicly accessible to train AI models, then the conclusion would be the whole processing activity would fall under the regime of Article 9. And that makes it by default prohibited unless you rely on one of the exceptions listed in Article 9.2. And then I started looking okay, what can justify this processing activity then? And the obvious one is actually what we also referred at the beginning, coming from maybe a bit of the understanding of what is out there in the public is not private anymore, that we have an exception that's called manifestly made public by the data subject, which allows the sensitive personal data to be processed if it is manifestly made public by the data subject. But when I was writing this paper, there was not much guidance on what actually this mean and this provision mean. And then I delved a bit deeper to the case law and the literature to understand to the boundaries of this provision, and I can give you from this the limitations of what can be used for such purposes. And the first one is the manifestly made that I would like to focus on, and that requires when we put our personal data out there on the internet, for instance on Instagram, it requires Instagram to ask us to explicitly opt in for the public disclosure of our personal data. Simply speaking, it says, hey, Instagram, do not make all accounts by default public, but let people decide to open their accounts to other people out there. But this is not enough. The CJEU also wants this decision to be made with the full knowledge of the facts, which I believe that means that we need to be informed by, in this example, Instagram. What would be the possible outcomes or implications of such a public disclosure? So for instance, here they need to put in their privacy policies, or maybe while we're making this decision, make sure that since we're talking in this specific context, your pictures could be used to develop Gen AI models, etc. So then, for instance, people can make informed decisions about publicly disclosing or not their personal data online. The second one is public, which is quite straightforward. It requires the personal data that we're talking about and may be processed for training these models to be accessible by anyone on the internet, basically. And it derives from earlier days of data protection judgments even, and it's basically coming from the idea that if something is out there online, it is accessible by anyone and anything on the internet. But I would like to a bit challenge that idea, because then it made me question when I was first reading on these judgments, etc., to understand what public means in this context. Because imagine. Because actually, I will also tell you how it started. I started working on a concept that is called household exception, which Aimen would understand now. It's basically speaking, meaning that very personal things that you post on on your Instagram profile, such as or maybe that was a wrong. So I'll start from the the example could be for instance, if you run a birthday party and you create a WhatsApp group or something like that, those kind of small personal interactions that you carry out in your personal life would not fall under the GDPR's material scope. So it basically to save those kind of interactions from the legal scrutiny. So then I started seeing some decisions from data protection authorities that they are not actually applying household exception when it, for instance, there was a dispute of a grandmother posting the grandchildren's picture on their Instagram page, and one of the parents were opposing this, and the data protection authority was saying that, well, we apply GDPR because your account was not restricted and stuff. And obviously you don't see those facts there, but I was also preparing exam questions and stuff, making it a bit chilly, and then I was putting some details. But imagine if that grandmother had only 20 followers, no hashtags, nothing, but just simply because that account is not restricted. Do we really accept it as public? Whereas, for instance, I guess it's Cristiano Ronaldo has the most number of followers, but maybe I'm just giving a very archaic answer here. I don't know, but imagine someone who is that person has the most followers on Instagram. Let's say hundreds of millions of followers, but it's a private account. So then are we going to count it as private or public, or private just because it is a closed account, but in the sense it's public because millions of people are following that account? So it also made me question a bit is it really still a valid argument? But overall, coming back to the point, yes, the public means here is that it needs to be accessible by anyone on the internet. So the last one is by the data subject. And it's again quite straightforward, but tricky. Because, for instance, I may put my details on certain websites or whatever, my personal data, myself. But for instance, this podcast will be I don't know, like shared or broadcasted or whatever. And my personal data will be shared by third parties. I'm not talking about whether I allow it or not. It's totally out of context here. It's just like who does this kind of thing. And if you think of these kind of examples on a very broad scale, that you think of like public personas, etc. Like you have social media posts, you have media, sometimes facts that are even not true shared by those people out there online. So overall, coming to the conclusion, so you need to comply with manifestly made, public, by the data subject, all these components in order to be able to actually use these data out there, publicly accessible, for any purposes, not like just to develop these models. But in this context, developing like Gen AI models through mass processing or like data trolling, it would mean that not all the data included in these data sets are actually complying with these requirements, which would necessitate them to actually limit, somehow go back to like drawing board and exclude maybe certain types of like sources that they used or like websites, etc., which is also like asked already for the legitimate interest discussion. But I think like the discussion there being held in Article 6 rather than Article 9 is a bit of a problematic because of these CJU cases that I mentioned. And sorry for the long or maybe like the very technical legal answer to your question.
Okay. So I wrote a couple of things down. And one thing, and because it recently came up in the news, that there was discussion that you should have the possibility to opt out of data, of the gathering of your data. And I thought that's the wrong way around. It should actually be that you have to opt in. And actually, that's now what you're telling me, that you gave the Instagram example, that you have to opt in to have your data shared. Of course, if you say, well, it has to be an opt-in, then probably nobody will opt in, or they hide it somewhere in their rules and regulations that if you use that tool, then you're automatically opting in, which I think can be legally fought again, because if you hide something in there, you cannot really say that people agree to that. So to what extent is this now, let's say, in a sort of a proposal phase, and where are we going with this?
Yeah, definitely. We are more focused on how to make sure opt-out requests are like being respected and definitely implemented, which are also implemented in the obligations in the GDPR. But I think it's a start for sure, but I'm not sure whether and to what extent it really complies with the realities of the world that we live in, because the thing is, opt-out by its nature requires us to take certain actions, informed actions. And I can give you one example from my PhD research from a different context. For the investigative genetic genealogy, there are two main databases are being used: Family Tree DNA and GEDmatch. And so one uses an opt-out regime and the other one uses an opt-in regime. So there is also a bit of the discussion whether and to what extent people who are opted in by default are actually agreeing with these practices. So coming back to this data trolling issue again, maybe it is also the place to now explain a bit what I see that may happen or maybe may not happen, given the too much focus on Article 6 discussion nowadays. So these quote-unquote data trolling activities to train AI models are also not something very new, because we already had certain techniques being used for various other purposes, such as academic purposes, like journalists, archiving purposes, and most interestingly, search engines. Because they also use certain tools or technical measures to index information out there for their search engines. And that was also one of the questions was asked to CJU, Court of Justice of the European Union. They say, well, what is the legal basis to do so, especially regarding the special categories of personal data? And there, I think the court, understandably, made a very logical move, because they created a specific exemption just applies to search engine operators. Because, for instance, the Advocate General, I remember saying that it is neither desirable nor practical or something like this. It is, anyway, so it's saying something like just obliging search engine operators to check in all, the websites that they are indexing, which types of personal data is being listed there, and what would be the legal. But it is definitely not something that we desire or we can implement in the world that we live in. So that's why they came up with a special exception, I would say, like a de facto exception for search engine operators, that we check the legality of this processing activity ex post rather than ex ante, that you need to do in any other types of processing activity in principle. But there, when and I think that this discussion took place around 2019, and one of the criticism I remember from reading the articles around that time was that yes, it is a logical move, but we also task individuals to enforce their data subject rights by being aware of this processing activity, or take actions rather than making the data controllers comply with the obligations. So, but I definitely understand why this exception was created, because otherwise it would be really counterproductive. But anyway, so then I started thinking, okay, can large language model developers or any other AI developers using these data trolling techniques rely on this exception? And one of the things that I wanted to mention regarding the differences is that it is easy for us to identify and take action regarding the search results or personal data processing activities taking place by search engine indexing. But it is not that easy to do so, at least for now, or at least to my knowledge, to do so regarding Gen AI models or large language models, because based on the prompts or something, it can give different answers, and I have no idea if you put my name out there, in which context or whatever, what kind of outcomes it the answers it provides you with. And it has accessibility issues because they have different types of model capabilities based on your subscription whatsoever. So it's not something like Google that we go and in principle, again, it's obviously different, I know, but in principle, it is more or less the same and transparent to everyone that reach out to the same results when you type in something. So. And again, I know this is a very, very abstract comment. It's not really happening in practice, but just to show you the difference between the search engine and the large language model. And with this idea in mind, I'm not sure how effective it is or how fair it is to actually task people to opt out from the data sets or something. But definitely, speaking from the practical sense, I cannot also see any other solution out there, but it may be because of my technical incapabilities or ignorance. I would love to see and discuss more options, but yeah, this is a bit of a dilemma, and that's why I also finish a bit the paper by saying that we need to make a decision, and all those decisions have some ups and downs. If we literally apply or what is out there regarding the jurisprudence and stuff, we may feel the rhetoric GDPR kills innovation and all those kind of things. But if we allow yet another exception to be used by yet another big tech giant out there, it also starts a bit questioning legal clarity. And someone on I think it was on LinkedIn made a comment, and I had never thought about it, that we create exception after exception for big tech companies, but what about the coffee shop in the corner where we go full throttle regarding EU data protection compliance? So those kind of questions that we need to also discuss and answer. And I see more and more that we're going towards a bit like, okay, like we have this tool and it's been embraced by consumers, so let's find a solution. I'm fine with it, but it doesn't take all those questions out of my mind.
Yeah. So the big issue here that I see is that there's legal battles be fought, and you fight it over the term search engine. For instance, is a large language model a search engine? Because I know that some of these big tech companies claim that, and probably because of what you say, because search engines get certain exceptions. There's a lot of money involved, and a lot of I heard arguments of OpenAI that basically came down to, yeah, we steal, but we steal from so many people that it doesn't matter anymore. So, of course, in a very paraphrasing way, but that's what it came down to, because they steal from the whole world. So who cares? The whole world can use this stuff now. And the problem is, of course, that technology runs so far ahead, and then lawyers try to keep things a bit in the background and delay those battles, etc., so that in the meantime everything can be misused. Let's say that's how I would characterize it. So maybe can you say a few words about what the future would look like in your vision? So you come to certain conclusions. So what should we expect, like say in the coming 3 months, 6 months, where this is going?
I think it's a very hard, if not impossible, question to answer, because it's such a dynamic field. Like things happen every day, every second. It's really hard to like guess. I can give you this example. I was in Copenhagen recently, and I was asked to give a talk on the paper, and I can't really remember whether it was that day or the day before. DeepSeek came into being, so to say, and like everyone was like, oh, there's this like a large language model, but there's this new concept that is called distillation. I was like, wait a second, like I don't have time to go through and renew my slides and having that panic attack, so to say. So just through that example, I can give you that how the example of how dynamic the field is, and it's really hard to estimate. So I think it was one of the reasons that the well-expected opinion from the European Data Protection Board came a bit disappointing, so to say, to the European data protection scholars, because when you check that opinion, it says, yeah, these are the principles, these are the rules, remember, and we also make sure that we will apply these, case by case, remember that. So nothing concretely being said. I think definitely for this reason too, that it's such a dynamic field. We don't know the answers yet, what is happening with the data, the training sets, and what is the logic behind it. How can we implement, if even we could implement the technical measures and stuff. So I think it's a bit of the point of hesitation, exactly for that point, that we don't know definitely for sure what's expecting us in even not in 3 months, but in 3 days.
And I would kind of say that's the kind of difference between the legal perspective and more of a computer science perspective, that we do have to take a step back as lawyers and look at the situation evolve before we can actually comment on principles or comment on how the law should look like, because these things, laws and principles, we view them as being more they're more set in stone for us, so that we have some kind of a point of reference. But I would understand that in computer science or in more developmental fields which focus on the next model or the next version of certain technology, things are more dynamic. So which is why I really liked your very calculated response, because I think it really reflects the kind of dilemma that we're all in the data protection circles and also in the legal circles.
Mm-hmm.
So yeah.
I definitely understand people looking for binary answers, yes or no. Tell me, is this legal or not? But I'm not sure if it's just a Turkish saying or an international saying, where there are 2 lawyers, there are 3 opinions. Mm-hmm. So we're a bit like that as well. As you may have also get it from my answers as well. Yeah, we have this option, and this option. If you follow this option, then you go to this, and this option will take you there. But when I worked as a lawyer, and especially regarding compliance with data protection related issues and stuff, it was also one of the challenging points for me as a lawyer to make that message, like, convey that it is not really that binary, like, yes or no, or like, yeah, you'll get definitely fine, but like, that fine could depend, or like, yeah, this is fine, but if you do this, then you may be in trouble. So unfortunately, like, regarding the legal sense, at least I, like, maybe as a PhD researcher, I cannot foresee it now with the lack of seniority, that I cannot really predict, like, where we will find ourselves regarding, like, these decisions and all those kind of issues that is, like, being pending. But yeah, at least it's definitely interesting for me to, like, read and hopefully write about it.
Yeah, and as a PhD student, you still have a long way to go. So.
Well, I hope so.
in this field. Thank you. Anything last things you want to add?
No, if you have any other questions.
No.
I think this is great. Thank you very much.
Thanks for having me.
All right. Thank you, Taner, for that wonderful conversation.